नमस्कार दोस्तों, हमारे शॉर्ट हैंड लैब प्रयागराज चैनल पे आप सबका बहुत बहुत स्वागत है। मैं आपको लीगल डिक्टेशन प्रोवाइड करूंगा जिसकी स्पीड होगी 100 से 110 वर्ड पर मिनट के बीच। 538 वर्ड की डिक्टेशन है। आप लोग डिक्टेशन के लिए रेडी हो जाएं। स्टार्ट। मिस्टर तुलसी कॉमा द लर्नेड सीनियर काउंसिल अपीयरिंग फॉर द appellant contended that though the power of the appellate court to interfere with an order of acquittal is the same as against the conviction, but the appellate court is duty bound to focus his attention to reasons advanced by the learned trial judge in discarding the testimony of the witnesses and the circumstances under which the trial judge came to the conclusion that the prosecution has failed to establish the case beyond reasonable doubt, and the aim not having been done, comma, the impugned judgment cannot be sustained, full stop. Mr. Tulsi also further contended that a bare perusal of the evidence of PW 7 and 13 would unequivocally indicate that they are wholly unreliable witnesses, which is apparent from the omissions in their statement recorded under section 161, and the High Court has merely brushed aside the same and then recorded the conviction of the appellant of the offence under section 306, full stop. The learned counsel appearing for the state, comma, on the other hand, comma, contended that the High Court as court of appeal was well within its power to interfere with an order of acquittal, and good reasons having been given, comma, the same could not be interfered with by this court in exercise of power under Article 136 of the Constitution, full stop. The appreciate the correctness of the viral contentions, comma, we have been taken through the judgment of the learned sessions judge as well as that of the High Court, which clearly reveals that the High Court has not considered the reasons and ground on which the learned sessions judge discarded the testimony of the two witnesses PW 7 and 13, as well as the circumstances which led the sessions judge of come to the conclusion that the prosecution case has not been proved beyond reasonable doubt, full stop. On the other hand, comma, the High Court has entered into an arena of surmises and conjectures and has interfered with an order of acquittal recorded by the sessions judge, full stop. Therefore, comma, we have no hesitation hold that within the parameters prescribed for interference with an order of acquittal, comma, the High Court has acted beyond its jurisdiction, comma, more so, comma, by not examining the grounds and reasons on which the sessions judge disbelieved the evidence of the two witnesses PW 7 and 13, and also the circumstances which believed the prosecution case, full stop. That apart, comma, we have also ourselves scrutinized the evidence of PW 7 and 13, and from the cross-examination of these witnesses, comma, it appears that the most material part of their evidence in court had not been deposed to while being examined under section 161, comma, and, comma, therefore, comma, by no stretch of imagination, comma, two witnesses can be held to be reliable witnesses so that the prosecution can rely upon their testimony for a conviction of the accused appellant, full stop. In the aforesaid premises, comma, it must be held that the prosecution has utterly failed to establish its case beyond reasonable doubt, full stop. The appellant is entitled to be acquitted, full stop. We, comma, therefore, comma, set aside the impugned judgment of the conviction and sentence passed by the High Court and acquit the appellant of the charges labelled against him, full stop. The bail bonds stands cancelled, full stop. The appeal is allowed accordingly, full stop. Thank you so much.